If a commissioner of the Department of Social Services is appointed guardian, which county's commissioner should be appointed? To find out, you have to read Matter of Kimberly D.D., but it's 5 pages. Don't have time for that? I've got you covered. This is TLDR, Too Long Didn't Read, where I cover New York Court of Appeals cases, and I try to do it in 5 minutes or less. But this is part of a special limited series I'm doing on cases relevant to the elder law and estate planning community. This is the case, a recent case of Matter of Kimberly D.D. out of the Appellate Division 3rd Department. The citation for this case is 2023 New York Slip Opinion 05298, published by the Appellate Division 3rd Department on October 19th of 2023. The issue in this case is which county's Department of Social Services should be designated as the guardian for an incapacitated person, where they live, where they actually live, or the county that provides them Medicaid services. I'll explain all that in a few moments. The background that I think is helpful to understand this is that there's a couple of different provisions that talk about residency that are relevant here. First, under Mental Hygiene Law 8105, which is the venue provision for guardianship, it states that a guardianship application should be brought in the county where the alleged incapacitated person lives, where they reside. And if they live in a facility, then it's the county in which that facility is located. That's considered their residence. So even if they have an apartment in Rochester, if they're a resident of a skilled living facility, a skilled nursing facility in Suffolk County, then their residence for Mental Hygiene Law 81 purposes is Suffolk County, wherever the facility is located. Okay. The other thing that's helpful to know in this case is under Social Services Law 62, a county is responsible for providing public welfare services to any of its residents that need the help. And when they start providing services for that resident, then they're still responsible for that resident no matter where they move. Even if they go to a facility in another county, and they have to keep providing services. Okay. And the last thing you have to know is that under Social Services Law 473, one of the services that mental hygiene, that the Department of Social Services and the public welfare for the county is responsible to provide includes guardianship services. Okay. Arranging for, providing guardianship services. So what are the facts in this case? The facts are that the AIP, the alleged incapacitated person here, Kimberly D.D., lived for a while in Saratoga County. That was her original residence, Saratoga County. In fact, that's where she applied for and received Medicaid benefits. Medicaid is administered by the county. So she was a Saratoga resident, received Saratoga Medicaid benefits, and in 2013, she moved into into a skilled nursing facility in Washington County, New York. And she was there for 10 years as a Washington County resident for the purpose of where she lived, even though she was receiving benefits from Saratoga County. But her abilities declined, and 10 years later, in 2022, the nursing home filed a petition for Article 81 guardianship. The court conducted the hearing, appointed a guardian. There was nobody else to appoint. So the court appointed the commissioner of DSS, the commissioner of the Department of Social Services, of which county? Washington County, the petitioner, where she lived for the last 10 years. And when the judge appointed the commissioner of Washington County, Washington objected. Washington said, hey, wait a second. Under Social Services Law, the one I just mentioned to you, she's receiving Medicaid benefits from Saratoga County all this time. That's her residence under Social Services Law. So it should be Saratoga County's commissioner that's appointed. It goes to the Appellate Division, and they say the Supreme Court did not abuse its discretion in appointing Washington County as guardian. This is what's interesting. The holding here is they said the judge didn't do anything wrong by appointing Washington County as the guardian. But since Saratoga County has status under Social Services Law 62, right, as the residence under Social Services Law 62, for purposes of medical assistance and public assistance, the Appellate Division exercises its own discretion and changes who the guardian is going to be. They modify the judgment of the trial court and say, I know you didn't do anything wrong by appointing the commissioner of Washington County, but we are changing who the guardian is going to be. It's going to be the commissioner of Saratoga County, because Saratoga concedes that the IP, the incapacitated person, their residence district under Social Services Law is Saratoga County. And they say because of Social Services Law 473, amongst many services that the that the county has to provide for their residents, which includes the IP, that includes guardianship. So therefore, Saratoga County should be the guardian. Saratoga Commissioner should be the guardian, and they replace the guardian appointed by the judge, which is Washington County. And what's interesting about this case is basically this is instructing that the guardian of, if you're going to make DSS the guardian, it should be the county where they receive Medicaid benefits, not the county where they necessarily lay their head down at night. And maybe for Washington County and Saratoga County, that's easy. They're close to each other. But what if a person was receiving Medicaid benefits from Erie County and they lived in Suffolk County, which is 6-7 hours away? Under the rationale of this case, it should be the Erie County Department of Social Services that gets appointed, not Suffolk County, even though it's several hours away. But that's the case of Kimberly D.D., and have a good day. If you like what you just saw and want to see more just like it, please hit like or subscribe to let me know.